Good to have you along with us. Thanks for hopping in the rig because we're going to have another edition of Down the Road right here on Beck News. A couple of things we definitely want to cover today. Your utility bills, are they going up? Is this a reaction to what we saw happen in Texas? Are we paying the price for a private power grid that didn't know what the heck it was doing? We'll get into that issue a little bit later. Also, there's a school board member in Florida who gave a great speech at the school board meeting. And one of the things she pointed out was the way that those anti-mask individuals are basically making their case and the viciousness that they're using to make sure that they can make her life and others unbearable. But we're going to begin with subpoenas. We're going to talk about what we're seeing play out on a national scale. The January 6th Select Committee in Congress, and I might add this, a bipartisan committee, is taking a hard look at what was the cause of January 6th and what role government potentially could have played in it. To do that, they've got to subpoena people because some of those individuals won't come before Congress to testify. And so how do these subpoenas work? What repercussions can happen to the individual that won't respond to those subpoenas? Well, we're going to talk to Ross Nilson of Nilson Brand Law Firm. Ross, good to have you back on Down the Road.
Thanks, Joel. Thanks for having me.
Okay, what happens if Steve Bannon says, you know what, shove it, I'm not coming?
Yeah, I mean, subpoenas are used to get non-parties, so somebody who isn't a party to a criminal case or a civil case, and in this case, getting before Congress, to appear before them if they won't voluntarily. Typically, Congress has a couple other tools that they can use. I know one that they're considering is this criminal contempt, where they're going to the Department of Justice and saying, hey, look at this for criminal reasons. Some of the penalties I've looked into is it looks like maybe they could spend like a month in prison or jail in order to enforce it. But that hasn't been used in a really long time. And, I see Steve Bannon, he's claiming that there's privilege issues, and there's never been really any case law on whether executive privilege or any type of privilege goes beyond the presidency. So my guess would be is that Donald Trump, who's kind of directing these people that there's privilege, that this is going to take a while. And I think that's part of the play here is to draw it out, appeal it, just like he did while he was president.
Okay, so let's make that assumption that, they're not coming into that congressional hearing because they want to draw it out. If you put them in custody, for lack of a better way of putting it, how long can you? I mean, can you sit there as an incentive, or can you let them out, subpoena them again, put them back in, or is this one and done when it comes to the months?
I think what would happen is that they'd have to get the criminal contempt, and then a court would have to order it. Then they'd have to detain Steve Bannon or whoever it's going to be not attending. And then they'd probably go back to him and go, are you ready to yet? Are you ready to yet? And judging by how Steve Bannon is just personality, I think he's going to tell him to go shove it. I'll sit here for the 30 days. And then if he gets let out, I suppose they can try to subpoena him again and start it all over. But he might make the argument that you already tried that once. It's some kind of form of double jeopardy, which I've never looked into, to be honest, because this is a whole unique issue. In the past, when they've done this, and we're talking like 100 years in the past when they've done it, they've held people in criminal contempt. And I think usually it's an effective method of getting people to testify. But there's a lot of uncharted waters here. The courts haven't handled it before. I don't know how they're going to handle the privilege issue, because that's the main reason that he's going to invoke this, that he shouldn't be held in contempt because they're privilege issues. So I think what would happen is that they would bring the criminal contempt. He would use as a defense that I'm just asserting privilege, and the court would have to decide whether that privilege stands. And so let's say the court says, nope, there's no privilege here. First thing Steve Bannon's going to do before he probably tries to get stuck in jail is appeal it. Now, whether the court allows that, my guess would be is they're going to say, yeah, we're not going to put him in jail here yet because these are issues that need to be decided. And before we're going to stick somebody in jail for 30 days or whatever, that we need to have these issues decided. And even if you get in front of an appeals court, like an expedited appeal or something, you still got to have people doing the briefing, having the arguments, and all that takes time. And that's kind of been the method that it appears President Trump utilized when Congress was trying to get other subpoenas passed or get the information through the subpoena process, is appeal, appeal, appeal. And I mean, he ran out the clock essentially on a lot of this. And I feel like that's what's going to happen here, is that he's going to look to possibly run out the clock until we get to the midterms, and hopefully the midterms turn out great for Republicans. And next thing you know, this committee is just doesn't have any power anymore. Yep.
Well, okay, that led to another question, though. If the committee found its results prior to him answering the call, sitting in jail, and the committee, he can sit in there for 6 months, as you said, and then the committee comes with their findings in 3 months. Does that still then release him of the sitting in jail for 6 months?
I think that would be the argument his lawyers would make, is that at this point it's moot. And then the question would be, if the court finds that it is moot, or does it find that, no, you didn't follow through on what you were supposed to do or what we determined, and we're going to make you sit there. So that could definitely be a possibility. One of the interesting things with Steve Bannon is that he's invoking this executive privilege at the direction of former President Trump, but for the time frame that Congress is looking for, Steve Bannon was long gone out of there. And so the question is, does that continue to apply here? And then there's even a question of whether the executive privilege goes beyond when you're president. Obviously, Joe Biden has said basically, doors wide open here to a degree. We'll review whatever request you have, which, the argument has been made by President Trump, and I think there's also been some other arguments that you're really opening the door here for future presidents, that you might weaken the executive privilege. Now the question is that good or bad?
Yeah.
So
you sit there and you've got an individual in jail that wasn't part of the administration, that's claiming executive privilege. You're trying to get this information out and do it in a timely fashion, because all of us know that midterms are on their way and that the chance of the Democrats holding on to the House is slim. So if you're Nancy Pelosi, you're like, look, this is a tool that could be used in the midterms. I need to get this turned out. Can you garner enough information from what Steve Bannon had, documents-wise versus testimony-wise? I mean, do you have access to the papers?
Well, I think they would invoke, again, the executive privilege and not turn it over. And so then you've got Steve Bannon, in our example, stuck in jail, and you might not get that information. And I think that's the risk that they run, is that even if they get a criminal contempt, let's say you get someone, Steve Bannon or whoever, who is willing to just bide their time, they might not get that information. So I think they're trying to do their best to get the information, but it might play out to where they don't get everything that they need, and they're going to probably push this report out before the midterms. My guess would be they'd want it sometime during the summer so that they can play it up. And they could possibly use, Steve Bannon not cooperating as just another example of, what they contend, President Trump just, thinking he's above the law.
Okay. So do you, as Congress, I subpoena you, you're Steve Bannon, you don't come in, you basically tell me we've been using this term. I started it. Yeah,
Yep.
He says shove it. But does Congress have the power on the criminal side? And in the beginning, before they issue that subpoena, did they have to go to a judge to issue the subpoena itself?
I think, from my understanding, Congress has subpoena power, so they don't need to go before a judge. Just like as an attorney, if you're a practicing attorney, I can issue subpoenas in North Dakota without having to go to the clerk of court and requesting one. If you went there as a non-attorney, you have to go to the clerk of court and go, I need a subpoena for this person, and then they would issue it for you. They give it to you, and you could issue it and serve it out. Congress has its own form of subpoena power, but in order for them to invoke any kind of criminal penalty, they have to go through the Department of Justice, and the Department of Justice has to review it and make its own decision. And then they have to go and sell it to a court, because the court's going to be the one that's going to be issuing the order finding that there is some contempt.
Okay. So in terms of subpoenas as a whole, are there different levels? Are we talking about just, hey, this is the definition of a subpoena, this is the power they have? I mean, walk me through, the different layers or the different types of subpoenas.
Sure. I mean, it depends. So there's civil subpoenas and there's criminal subpoenas, but they really try to accomplish the same things. In my line of work, I do civil litigation, and so we try to find out as much as we can from parties. And by parties, I mean people who are actually named in the complaint or whatever. So think of it, plaintiff and defendant. If I need information from an outside source, whether it be financial information or some other, or information from some other party, I can't serve what we call discovery on them. I have to issue what this is a subpoena on them. And typically that's used to get documents from them. So you have to serve out a notice, which you have to notify the other party to that I'm subpoenaing, I'm requesting this information. You give them a set period of time for them to comply. They have the opportunity to come in and either request to quash it, is what we call it. So basically say, I don't have to comply with it, and here's the reasons. So let's say in our example, it's privilege. This is attorney-client privilege, I can't provide you that. And then if I send the letter saying, I don't want to comply with it, here's the reason, I'm moving to quash it, or they can move to the court to quash it, then the court decides whether that subpoena is good if the reason why they aren't complying is good, or they can say, no, that's not a good enough reason, or the court can modify it to try to get around that. So there's a couple different complicated methods. Now let's say I serve you a subpoena and you just don't respond to me. I can go to the court and say, let's find this person in contempt. On the civil side, that would mean getting the court order and then, typically requesting fees and other methods of trying to get compliance with it. Sometimes people just won't comply. And I think that's the problem that Congress is going to run into too, is that you only have so many tools in your toolbox. And if you've got people who are just saying, nope, I'm not going to comply, I'm willing to go to jail or whatever, which I think, because we've used Steve Bannon so much, to me, he seems to be someone who would just be like, it'd almost be a badge of honor, right, if you really think about it.
He doesn't shave anyway. So.
Yeah, right? I mean, yeah, and, the joke is he wears like 3 polos or whatever, so maybe that would be something, but...
One of them could be orange.
Yeah, right? So I think for him, it would almost be, a badge of honor. And then we got to look at it, too, from his perspective. We're about, 2 years away, 3 years away from another election.
Which means we're 1 year away.
Really, yeah. And so it looks like from everything you're reading that, Trump is going to run again. And so he's also playing his cards to a thing like, and what's one of the biggest things for President Trump? Loyalty. Loyalty. Will you go down with the ship? So I can totally see him just saying, I'll take the 30 days or whatever it's going to be. I'll just get my, get my hard bed and 3 meals a day, and I'll just take it out. And then when I get out of here, I'll write a book, and then maybe President Trump will put me back in the administration. I mean, I think he's thinking long term. Now, there has been compliance. We have seen that Chief of Staff Mark Meadows, he's complying in some form, either providing documents or other methods. So I think we're going to find out some of this information. It's just, I think it's going to be pulling teeth with some of it. And I think the Congress is worried they don't have the tools that they need in order to enforce the compliance.
When we come back, let's get a chance to visit about the Justice Department, which means to me, Chief Law Enforcement Officer, but also Executive Branch, and what role they play in all this, okay? Yep. Ross Nilson, Nilson Brand Law. We're going to keep going down the road together right after this. Welcome back to the conversation that I'm having with Ross Nilson, Nilson Brand Law. We're talking about subpoenas. We're talking about the power of subpoenas. And, of course, we're talking about it from the legislative side of government. What about the executive side of government? What about the Attorney General's office, which is the Chief Law Enforcement Officer for the United States of America? I want to talk to Ross about that a little bit. Ross, President Biden worked the rope line the other day, and he said, well, in his opinion, which is a danger, he knew exactly what he was doing. He didn't get surprised with the question. But in his opinion, there should be criminal charges filed against Steve Bannon, because that's the example that we're using. Yep. The Justice Department instantly came out and said, we don't decide by a president saying that. We'll decide on our own merits. I didn't know whether that was being a little disingenuous or not from the political standpoint, but why the mix if the House, if Congress has the ability to issue a subpoena and they have the ability to file criminal charges, what does the Attorney General's office have to do with any of this?
Well, I think they are asking the Department of Justice to review whether criminal contempt charges should be brought. I don't think Congress can go about, they can go and say that you're in contempt, but as far as being able to take someone and say you're in criminal contempt, take this to court and then put him in jail, that's a judicial function. So that's something beyond what Congress can do. So it's kind of a separation of powers. Now, how they're going to make that determination, it'll be interesting. My guess would be is that they are still talking with Steve Bannon's representation and saying, is there anything that we can do? Are you willing to give up anything? Or do we really have to go through all these hoops? My guess would be is they're being told no. That let's go through the hoops. No. Because the reality is that let's say they are successful at a federal district court level, right? And the district court says, yep, he should be found in criminal contempt. And what's the penalty is going to be? What I've seen from reading is it looks like it could be 30 days. But maybe the court says it's 15 days. And what Bannon's attorneys are going to do then is likely do an emergency appeal. Before you stick him in jail, before you stick him there for a while, they might say he'll put up a bond, or they might just say, listen, you're going to take away his freedom. We deserve a chance to have some of these issues decided because they're executive privilege issues. Now, how long is this going to take? A long time. Mm-hmm. That's just the reality of it. Because
so it's part of your theme of stretch it out. Stretch it out. What we have here is a political investigation, not a criminal one.
Yep, exactly. And I mean, I think it plays into both parties' arguments, right? This is the perfect setup for what they have, because on the left you're going to have Steve Bannon, who is not loved. He's not getting Christmas cards from people on the left, and he's saying no, and it just plays into the dislike for him and for the prior administration, and he's saying President Trump is telling me to do this, right? And then on the right you have, this is all political. They're trying to stick him in jail. There's been prior congressional subcommittees where they haven't done this before. This is all a political attack. And for Steve Bannon, it's money in his pocket is the way I look at it. Why would he comply if he's looking for his bottom line? And
get a ghostwriter, write a book.
Even if he gets stuck in 30 days in jail, he'll go in there and talk about what he found in jail and
title it. They didn't even make me pick up trash.
Yeah, right. So to me this is all theater. It really is, and I think it has been to a degree from the start. What happened on January 6th, we all watched it, was shocking. Even for people on the right, it was shocking. But obviously, it's who benefits, right? And if you're a Republican and you support Trump, it doesn't really play to you to say, yeah, those were all bad people there. And for the Democrats in the subcommittee, I mean, I think we already know what the outcome's going to be. It's not going to say President Trump didn't do anything wrong. And so I think all this is political theater. It's all playing towards the midterms. And so, but what could come out of it is some decisions on executive privilege, which there isn't a whole lot. This is all gray area. And so you could either get it in your favor or not. And if you're a future Democratic president, this is going to be a big deal to you too, because it's going to affect your ability to claim executive privilege in the future.
That describes the whole Trump administration, though. The first time ever a president impeached twice.
Yep.
The first time ever a president this and that and another thing. And so, we talk about the left and the right when it comes to the political side of this committee, but nobody's ever going to accuse Liz Cheney of being a lefty. In fact, I don't think they'd consider her a moderate. She's very conservative. And so before she agreed to take that position on what could be a fatal move as a politician, my guess is because you had to see this coming. You knew these people weren't going to allow themselves to be subpoenaed.
Yep.
There had to be considerations given to her. And I'm trying to figure out what those could be, Ross.
Well, I follow politics, dabble in it, but I mean, she's, from in Wyoming. She has someone on her right challenging her. And I'm sure she's thinking, one, if I win, then that just helps my political standing. Mm-hmm. And if I lose, I can still use it to possibly run for president at some point.
Right.
So, and I think that like what you're saying is that, of course, there's handshake deals and promises being made, because why else would you go and stick your neck out when you're already getting pummeled by President Trump on a regular basis?
Yeah. Anyone who thinks the government doesn't make big decisions in the hallway doesn't understand government. There's no question about that. I don't want to let you go until we talk about the legal system, period. How did COVID affect it? Where do you, as one of the partners of a law firm, how are mechanically you making it work right now?
Well, I think a lot of it is one thing some of the courts discovered is that there are a lot of legal proceedings and hearings and different things that you can do via Zoom, right? And I think it was surprising to a lot of people, and especially probably some of the judges, about how effective it can be. And it saves people money at the end of the day, because people aren't having to travel. You're not having to pay your attorney to travel maybe 3 hours for a hearing that, you can do via Zoom. They don't have to travel, and you save yourselves, $500, $1,000, depending on what your attorney is charging you. I think it also caused a great amount of delay, because they kept just pushing trials back and pushing trials back. I know in talking with other, what we term civil litigators, there was a lot of trials that happened this fall that were pushed back. So when I talked with a lot of my colleagues, they're just swamped because they're trying to catch up on all these trials. On the criminal side, criminal always tends to trump civil trials, just because there's these speedy rights obligations and due process obligations. And I think the courts are very much aware that they have to try to get these criminal cases done before the civil case is done. Now, if you're my clients, that doesn't make you very happy, because you're sitting here waiting, for how long. And if you have a trial date and you have to get it moved, what I've been telling my clients is, I can't guarantee you that it's going to be 6 months before we get a trial date. I've had other courts say we've wanted to, vacate a trial date basically until we could try to settle something. And they say, no, we're not going to, because you guys either get it settled here in the next week, or else you have to have the hearing or the trial, because we don't know when we're going to be able to get you a 2-day trial again. Yeah. So, I think the courts are doing the best they can. I think the courts in certain parts of the state were backed up. COVID just made it worse. So, for people who are paying attorneys, and I understand they pay them a lot of money, it doesn't really do a whole lot of good to be like, just have some patience. Yeah. Especially like we were talking about, if you're getting divorced. Yeah. But I think that overall the courts are doing the best they can. And I'm really hopeful that like using Zoom, which a lot of the courts have, a secure form of Zoom, will be more efficient and save people money at the end of the day. And so we'll just have to see.
Okay. Well, I will tell you this, that if I were in one of those positions, I would want a judge that isn't afraid of technology.
Yes. It's kind of funny. I think that there sometimes we have a good mix of judges throughout the state. I think we have some that, have been practicing a long time. We have some that have been, obviously any judge has been practicing for a long time, but I'm saying, some judges that are in their 60s or 70s. And I think there was a lot of them that learned how to use Zoom, or else had someone help them how to use Zoom. And I think it's been effective, and I think it's that way throughout the country. Now, here in Cass County, starting in July, they said, we're going back to in-person hearings. So I think that there's definitely a desire from judges to have in-person hearings where we can, because especially when you have testimony, seeing someone on a screen versus seeing them face-to-face and trying to judge credibility is a big deal. So for attorneys, you have to decide, where does it fall in? Is this better to have it in person versus Zoom?
How important is it?
Yes.
Exactly.
Yep.
Ross, always good to have you on. Thanks, man.
Thanks, Joel.